Hello, I'm Dominic Walker, JMW's Inside Man, and I'm with Lakmal Walawage. Hello, Lakmal.
Hi, Dominic. Great to be here with you.
Good to be with you as well. And Lakmal specialises in intellectual property, is based in our commercial litigation department in the London office. Now, Lakmal, I never thought that you and I would be on the Inside Man talking about oat milk of all things, but there has been a dispute recently, and quite a high profile one as well, between Oatly and Glebe Farm. I just wondered if you could give a sort of an outline of what's happened, please.
Yeah, absolutely. I mean, Oatly is a brand that has grown massively over the last few years, with the sort of environmental message that it gives around its product and its packaging. Recently listed in the US, publicly listed. So it's a big brand, and I think when they noticed that Glebe Farms were rebranding to bring out products with this sort of concept of packaging that has now become known as wackaging, which is wacky packaging, I think they saw the mark Pure Oaty out there, and they seem to think they have a claim as to oat being combined with Y, and they brought up trademark infringement and passing off claim, not only in the actual words Oatly versus the word Pure Oaty, but also in other trademarks such as images to do with the carton and things like that. So there's a few things going on there. Ultimately, though, they lost the claim on all grounds. So it's 1-0 to Glebe Farms there, but yeah, it's an interesting case for IP lawyers and for clients who come up against these sorts of problems that show certain things that we need to keep in mind when something like this comes across your desk.
And you mentioned, like, Mal, the packaging and the intellectual property. I mean, many people watching won't know the ins and outs of intellectual property, but they'll know that these two organizations have had a dispute. And ultimately, what's the reason for that? Are these logos, are these words, are this package, is protecting all of that valuable?
It's of immense value, Dominic. I mean, they've brought a claim here that is very significant, because they felt that if they didn't protect their brand rights here, it could be a huge mistake, because they're allowing an entrant into the market when they could stop it, and that's the value of where the IP is. In the case itself, they've cited the wackaging that I just mentioned. When they brought that out a few years ago, their sales went like that because of this concept, and then they've gone on to protect that through a series of logo trademarks. So it's clearly a company that knows where their IP value is, and is willing to protect that, because trademarks, once your brand starts gathering momentum and a reputation, it becomes a very, very valuable key asset and tool to protect your market share, and you're entitled to do that. And yes, certainly they didn't win in this case, so they weren't ultimately allowed to protect what they sought out to do. But the strategic thinking behind bringing legal proceedings shows how much they value their own IP, and that should be the same for all companies in the digital age, really.
And I know that you represent a lot of business owners, entrepreneurs, that sort of thing. What's your practical advice for anybody involved in a similar sort of dispute?
I think it's important, and I would say this, wouldn't I? But I think it's important to get to a lawyer as quickly as possible, especially a specialist lawyer. I mean, looking at this case, if you didn't engage in IP law practice on a regular basis, you might think in a first instance, oh, it's Oaty versus Pure Oaty. That doesn't look identical. Marks don't need to be identical. They only need to be similar. Now, then if you had knowledge of that, you might think, oh, it's Oatly and Pure Oaty. Oh, that is similar, so there might be an infringement. But then that's lacking some other knowledge about, descriptive trademarks and how descriptive trademarks aren't allowed to be protected. That's actually how they lost this case in the end on that point. So I think it's important to get to a lawyer, because there are many niche and complex sort of tiny tests in IP that infringement cases that can turn a case on its head, that might not be necessarily sort of screaming out at you when you first look at a set of circumstances, but if you go to the right people, they will be able to point those things out and really get to the detail of what's going on.
Lakmal, thank you very much for your guidance there. And of course, if you'd like to speak to Lakmal, you can contact him insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.